Hi, everyone. Thank you for joining us for our September monthly meeting of the Law and Technology Initiative here at Northwestern University. Our program today, Legal Prediction, Possibilities, and Pitfalls. So we're recording this session, and you should have gotten the notice as you came to the room, but we'll make this available afterwards. We're going to make slides available afterwards as well. We're using a Google Doc for this session to share some information about the speakers and the topics and other resources. That'll also be a place where you can add questions to the Google Doc, and we'll use that after the presentations to ask questions of our speakers. And so I'm Dan Linna. I'm the Director of Law and Technology Initiatives and a senior lecturer here at the Law School at Northwestern and in McCormick School of Engineering. And I'm really glad to have three great speakers here today to talk about legal prediction. And this program wouldn't be possible without help from our law student research assistants, Sharon Mims, Alex Crowley, Hiba Sheikh, Hitch Thompson, Katie Nagley, and Chandler Keller. And so each of them are on the call today during their session. They're going to be taking part in the networking session that we're going to do later on at the last half hour of this, and we hope you stick around for the networking portion of that. So we have three experts here with us today who have been using data in law practice for a while now and are known for their expertise in their use of data. So we're pleased to have them today. Megan Irwin from Bryan Cave, Leighton, Paisner, Jim Yoon from Wilson Sonsini, and Diana Koppang from Neal, Gerber, and Eisenberg. And what we're going to do is we're going to hear from each of them for about 9 minutes, 8 to 9 minutes. They're going to give a presentation. I know that's not a lot of time, but one of the things we're learning about in this online world especially is to try to break down content into short snippets. So you'll hear some highlights of the work that they're doing. And then again, like I said, we are sharing the slide decks. We'll make sure that those are available through the Google Doc later on, and we'll send them out via email. So we'll have three presentations. We'll hear from Megan, Jim, and then Diana, and then we're going to have open question and answer for 30 minutes until the top of the hour at 1 o'clock here Chicago time. And after that, we'll do 30 minutes of networking. We'll have three sessions of the networking, and I'll explain that in just a minute. So we want to thank LKQ Corporation for supporting the Law and Technology Initiative here at Northwestern University. Again, please submit your questions on the Google Doc. This is something we've experimented with before that's worked pretty well. If you see other questions that people are asking, you can kind of indicate upvoting of that. It's a little bit of a lower tech way than having the full platform, but we've found that it's pretty effective. Please tweet as well. We're on Twitter at NLawBizTech and use the hashtag NLawCS. And we'll retweet your tweets. So please put it on Twitter, LinkedIn, Facebook, whatever your favorite social media platform is. And the networking session, we're going to use breakout rooms. We're going to break people into randomized groups of 5 or 6, depending on what the final number of attendees is that we have for the session. So we hope it's a little bit of an experiment, but we're trying to recreate some of what we do in these in-person events and give people an opportunity to meet with some of our presenters, meet other people, and we'll keep improving on that and see different ways we can try the networking, but we hope you'll stick with us and experiment with that. But with that, what I'd like to do is turn things over to Megan Irwin. And so Megan, hopefully you should see your slides now. I do. And let me give you control so you can go through your slide deck. There you go.
All right, let's see if I can get this to work. Yep. Okay. Little delay there. Let me get back.
Well, here, let me go to your first slide.
Okay, here. Thanks. So I'm Megan Irwin again. I'm a partner with Bryan Cave, Leighton, Paisner. My substantive area of law is actually environmental, which I will not be talking about here today. Also, within the firm, I serve in a role that we call a relationship partner. And in that role, my job is really to, with a certain client, service the main liaison, whatever area of law needs they have, and helping connect them with the needs of the firm. It's in this role that about 10 years ago, I got dragged down the rabbit hole of analytics with a high volume litigation portfolio that I manage for U-Haul. And So what I thought I'd do is just kind of take you through the case study of how the challenge was presented to me and how we evolved that for the past 10 years to use that analytics to start to inform some of our legal strategic decision making. I may have to advance the slide, sorry.
Yeah, your audio is breaking up just a little bit too, but
How about now?
There, that's better. There we go. Yes.
Okay.
Yeah.
Dan, could you, thank you. Okay, so originally the client came to us, U-Haul, and they had a very high volume, low dollar insurance litigation portfolio. It was all in a very specific jurisdiction, pricing under statute, but it was generating 500 cases a year. At the time, they were using multiple small insurance defense firms, and it was just getting exceedingly more difficult for their in-house department to manage this. Between these small firms, that this is the only work that they did with them, and at the same time managing their higher stakes portfolio. So we had done already a lot of litigation with U-Haul, and they came to us and said, would you partner with us on? We'd like to consolidate all of this into one firm. And we know this is not the area of law you do, but is this something that you think you could help us with? So, I rolled back to our management, and they directed me to our technology team, which 10 years ago, I didn't even know we had these resources. And, lo and behold, I find out that we have data scientists and we have software engineers, and working together with the client and our just technology team, we figured out, how to put people and process and technology together to say, yes, we think we can take this on. So our original challenge was we were going to be inheriting all these cases, hundreds of cases, not only the new ones coming in every year, but also the historical cases that we were going to be transferring over from other firms. And we had one goal in mind, which was matter management, just something for our attorneys to use to keep track of their cases. If you could advance the slide, Dan. Thanks. So the first thing we did was, and when I say we, I mean the technology folks, was put together a really basic database, and not very interestingly, we called it the data collector. So this was just a place to house the most basic information that our attorneys would need to access, like the plaintiff's name, who's opposing counsel, what court is it in, your deadlines, and maybe some notes for your litigation notes. Over the years, in working with, kind of fast forwarding over the past decade, with a lot of iterations, a lot of collaboration with, the client, the technology team, the working attorneys, and myself as the managing partner for the program, we started refining it. We started adding more pieces of information of data that we were collecting. Again, originally for really more of the working attorneys to be able to sort of sort and filter on their cases the way they wanted to be able to. But, within a couple years, we realized that we were starting to, we had a lot of data and we weren't really doing anything with it. And I really didn't know, how the program was doing. I knew, the client, we weren't getting, the client seemed happy and we weren't missing deadlines. But other than that, I didn't really have a sense of, are we winning? Are we losing? Are we driving claims down? Are we driving costs down? So the first thing we did with the data, pulling it out of the data collector, was just trending these types of things, try and get our hands around how are we doing. And, once I started to see that data be visualized, it gives you more ideas of what you can do with it. So, originally why we started collecting information like, at the end of the case, did we win, did we lose, did we settle? Fast forward, as time goes on, we now collect information like what was the amount of controversy in the beginning of a case, what was the ultimate cost of resolution, what was the amount of interest that accrued over that period of time, what was the duration of the case, so that we can then start to trend this stuff out and make legal decisions based on it. So next slide. Thanks. So I brought here today just a few examples. They're pretty basic. I probably get 20 different trends that I follow on a regular basis. But what this is here is, basically case volume over time. And I think a couple key things about sort of using the data and metrics and in making, you know, decisions around it is one, we had a closed world of data that we knew that we could rely on. It's all data that we inputted. We weren't guessing if the data was reliable. And then, you know, another kind of key point though is even when you look at the data doesn't tell the whole story without the human element and understanding kind of what's really going on. So I can look at these graphs and you know, I know that there was actually something else going on these first couple of years, and some of these bigger you know, differences. But when you get down to the more fine-grained points, these are things where it directs you to start looking closer at things. Next slide. So, you know, another type of thing that we track is the case duration over time. And if you can see over on the left-hand side, when we first took over the program, you know, we were about 5 years to case resolution. And, you know, as we trended out, it starts originally going in the direction that you think it should go, which is down. We're starting to resolve cases quicker and quicker. But it's at this point at, you know, around 2016, the data starts taking a little bit different turn. And what that tells you is that's where you need to start looking. But, you know, if you're following it in real time, it starts to give you an indication that you need to sort of drill down and understand, you know, what is it that's causing that change in the trend? Is it, you know, something that we can improve upon? Is it that plaintiffs have taken a different tact that we're adjusting to? Is it an internal change that's happened in the client that we could adjust to? So it's looking for those changes in the trend to tell you where to look and then where to go next with your decisions. Next slide. So this again, pretty basic trending, and I've taken off the values on sort of the left-hand side there. This is attorney's fees over time. And you'll see here, you know, back in 2011, when we first took over the case, as you might imagine, we weren't extremely efficient, and we were also inheriting cases that were in all kinds of shapes and forms that we were dealing with. And so, but pretty quickly, we, you know, drive the cost, the fees, the attorney's fees way down. And then, as you'd expect, the fees kind of start to keep going down as we're, you know, getting more and more efficient. But again, it's at this point in 2015 that you want to look, you see the trend start to head the other way. That's my signal point as I'm watching it again. And, you know, I get these reports weekly or whatever frequency I want, that something's changing, and diving into the data and then rolling back to your working attorneys, you know, talking with the client, finding out what it is that's changed. And is it something that we need to, you know, take a different strategy on, or is there something that we can improve upon? Until you see the trends start heading down the way you'd expect it and the way what your goal is. Next slide. So, you know, this was, I think it's an example of, you know, Rome is not built in a day, and it, you know, data analytics is not something that I ever thought that I would be involved in. And here, you know, 10 years later, I seem to live in it, and it only gives me, every time I look at it, you know, another idea. I mean, you see it trending, it gives you an idea of something else to trend. But I would say, you know, when I think of my practice and what I'm doing with data analytics, I don't know that it gets quite to, you know, the level of what I would call legal prediction. But I do think it's, you know, it's utilizing this reliable data to follow the trending and make better informed decisions, and that you can really make strategic legal decision making based around the data if you have good, reliable data to use, and you understand what's going on, and you have access to understand what's going on behind the data. So I think for anybody that's here today probably is already, you know, on board with this concept that, you know, law and data and technology are really, you know, here to stay. And it's something that, you know, really can be a differentiator for your legal practice if it's something you embrace and you're looking for ways to incorporate technology and data into your practice. And it really is sort of this, like I said, win-win-win. You know, more work for your firm, more areas of work you can take on, and better results for the client, with the added bonus of really being able to visualize the data and be able to use it as a communication tool with your clients. Your clients can use it as a communication tool with their internal clients, and it helps explain the greater picture and look for areas where there's possibilities for growth. Thanks.
Great, thank you, Megan. All right, and now next we're going to turn things over to Jim Yoon at Wilson Sonsini. Jim, I just shared control of the screen, so let's see if we can get the slides moving for you.
Yeah. Hi, everyone, and yeah, thank you, Megan. I think that it's a good segue from what Megan was talking about to what I'm talking about. So by way of background, I am been at Wilson Sonsini 25 years. I am a trial lawyer. About 85% of what I do is IP litigation, patent litigation. The other 15% of what I do is IP risk assessments, modeling, kind of prediction. And one of the things that I do very much agree with Megan on is the issue that, you know, law, data, and technology is a win-win-win. I think the difference from what Megan was talking about and what I'm going to talk about is it's a very big difference, though, talking about a population of matters and then optimizing to a population versus making a decision on a single matter, right? In a single matter, even if you have a 5 out of 6 chance of winning, you know, you could lose, and for your client, they experience 100% of the loss. So it's a little bit different when you're talking about using this technology in a single transaction or a single matter, which is what I do typically. And so absolutely, I agree that many aspects of litigation are predictable, can be managed effectively. I think the key is smart, effective decision-making that aligns the company's litigation strategy and business interests. And I think there are lots of tools today that would help in-house counsel, outside counsel make smart, cost-effective litigation decisions. These tools provide predictions, forecasts, statistical frameworks that can aid in the decision-making process. I think, as Megan pointed out, was the human aspect. And what all these tools, when you're dealing with a single matter, a single transaction, a single litigation, is that they enhance communication, they can increase trust, and they can build confidence in the decision, and hopefully give you the edge that you need in this. If we can advance, does this advance? I'm not advancing here. There you go. Thank you. So the key to this is the promise, right? Obviously, given that we now have data that goes to the risk, the court, opposing counsel, you can model and get odds on the decisions. You can predict timing and budget. You can systematize many things with automatic software, automatic document collection, even automatic brief writing and legal research. But ultimately, from the standpoint of a single matter, is you really want to implement the 80-20 rule. What is the bang for the buck? What is the thing that you can spend your limited resources on and have the best advantage or get the most leverage in your negotiation or litigation? Daniel, could you advance the slide? Yeah. And so here's the very important thing that we haven't talked about. If you're a litigator or party today, there is a massive amount of data. Everything I have filed since 1999 is available online. There is a very deep and distinct digital fingerprint for myself and my clients. And as people become aware of these tools, you have to realize that the choices you make in prior matters will influence how people will think of you this time. If you settle all of your cases in 100 days, and then on the 101st case, you go to the other side and say, we're going to go to the wall, we're going to fight a war, we are never going to surrender, no one is going to believe you. If you hire a lawyer that's never been to trial and say, I'm going to take you to trial and win, no one will believe you, right? And so one of the things you have to understand, especially for the law students and people, I'm not talking about when you're an associate and you have to do what the partner says. But once you start your career, especially if you're a partner or especially if you're the in-house counsel deciding for a company, the decisions you make this week will affect how people react to you next week. And you need to be constantly aware of your own digital footprint. So let's go to the next slide. So today there is a tremendous number of tools. So I do a lot of patent litigation, so I can investigate anything from the patent history, the company history, the counsel history, the court and judge history, and recognize that everyone else can investigate you. That it's not a one-way street. You must understand that both of you are being investigated. You can model it, you can decide it, and you can use it to make better decisions, and you can empower your client so they feel confident with the very limited resources that they have, they're spending it the best way. Financial resource rationing is a reality of our business. Nobody gets to spend all the money that they want absent a very few number of firms and a very few number of cases. So you have to decide how to wisely spend your money. Next slide, please. So you can use it in any number of things, from pre-suit diligence to selection of counsel, budget, discovery, motion, and strategy. So Daniel, if you go to the next slide. So I'll give you an example. So here's just two companies that are very common in litigation. One company is what would we call an NPE, or a patent licensing company. They filed 251 cases. None of the cases have gone to claim construction. None of them have gone to trial. No cases lasted more than 388 days. And the law firms that they hire actually typically get rid of cases in 140 days. Looking at this, you clearly know that this is a company that seeks cheap, quick settlement. They don't want to litigate. They're going to pay what I call cost arbitrage and try to offer something cheap and get it settled. And then you should budget and respond accordingly. If we could get the next slide. In contrast, here's another well-known company. This is for a company called Intellectual Ventures. They're well-financed, and they only had 76 cases, but look at this. 27 of the 76 cases reached claim construction, which is a very kind of substantive event in patent cases. 3 of them reached trial. Their average case is 449 days, which is twice as long as the other plaintiff. And that would tell you how you should respond. You can do the same thing as to counsel. The next slide. Now, one of the things that you have with the client is deciding whether to file a motion. So in a patent case, one type of invalidity motion would be a 112 motion. Is it a good idea with this judge? Everyone decided between 2010 and 2017 was denied. All these people probably thought they had a good reason. So you need a really good reason to recommend to your client to file such a motion. Next slide. In contrast, there are other motions where the court could grant it, and this would be an example of a 101 motion. I have limited time, so if we could just advance the slides here, a couple. One here. So basically, stop here. You can use, just back up, you can use the analytical tool to identify what are the successful motions and how to tailor yourself to the judge. Daniel, if you go to the next slide. So, for example, you could go to the winning motions and find out what are the characteristics of the winning motion, and then use other analytical tools so you maximize your impact to the judge. In particular, you want your writing to be something that the judge could see she or he is going to issue. If we just go to my last slide, Daniel, because we have limited time, I'm happy to discuss any of these slides during the breakout. The key thing to understand is the pitfalls, is that litigation decisions are made on a case-by-case basis. Except for routine matters, the data sets will be incomplete. Sometimes the judges haven't been on the bench long enough. You're dealing with an individual judge. The quality of the data is insufficient to provide robust, accurate results. You're looking at trends, tendencies. The data sets will never take into account the different risk tolerances of the parties, the psychological or emotional framework of the parties, or quite frankly, sometimes you have a witness who just is creepy. Right? I don't care how good your odds are. If your main witness is someone everyone is repelled by, probably shouldn't be looking at the data to decide the matter. It's a human business with all its strengths and oddities, and the goal of the data and the analytics should be solid communication, consideration of the issues, and the decision that takes full into account the data available. I view the data and analytics as a baseline for a good discussion with the client. I think I'm still within the time frame.
Great, thank you, Jim. Diana, let's see if I can get you set up so you can advance your own slides. 1 second here, try to give you control. You should have remote control now, so give that a shot, but if not, let me know and I'll advance them. Oh, you're on mute, I think, Diana, we're not.
All right, sorry. Yeah, if I have any issues, I'll just ask you to advance. If Megan and Jim have convinced you that analytics are something you want to use, and hopefully they have, what I'll talk about is how do you know which platform to buy, and possibly a multitude of platforms. So by background, I'm the Director of Research and Competitive Intelligence at Neal, Gerber, Eisenberg. We're a 140 attorney firm in Chicago, and our largest practice area is IP, and that's actually my subject background, what I've spent the most time in, which works well because a lot of the analytics platforms really started in IP litigation, specifically patents, and has grown from there. So what I want to talk about is a study I did with a number of librarians in partnership with analytics vendors. Our conclusions that came out of a large-scale testing project. So what we did is we focused really on what I call docket analytics. I see right now litigation analytics being divided into 2 areas. Docket analytics is more concrete data points. So think of things that are numeric, timelines, number of results, dollar amount of remedies, that sort of thing. Whereas you get into the semantic side, it's really looking at the text of the case. It's largely having to do more with the text of an opinion. There is some overlap with semantic, also enhancing docket analytics. So in terms of deciding if a case is a patent case or a copyright case, when you don't rely just on a nature of suit code, or deciding if the case is a win, what was the outcome, that sort of thing. But we really, again, focused on the docket side of things. Let's see if I can advance. Can you advance to the next slide? Okay, so these are the 7 platforms we tested. We focused on federal district courts. The questions had to be answered with just the analytics platform. So they weren't supposed to use docket analytics. They weren't supposed to use docket search platforms. So just going into dockets and counting, which is really the old school way of doing analytics that we did for years, was running searches across Paisner and literally counting and tabulating manually all the results. And again, we focused on the docket, not the case law. And what we wanted to make sure was key, we didn't want the vendors to think we were just out to break their platforms. All the questions we used in the testing were generated from the testers and from the platform, we had group leaders. They came out of actual questions we had been assigned by attorneys in practice, you know, with changing, of course, confidential names of clients and that sort of thing. The comparison spreadsheet we created at the end does include some state court coverage, but again, the focus of the testing was on district courts because that was more uniformly covered across the platforms. State court coverage is really still in the early days right now. Next slide. So this is just a quick overview of how we did this. We had 27 librarians from firms and academics, 4 leaders, 7 platforms. Each tester took on 2 platforms. We ended up with an odd number of 16 questions because we thought of another one toward the end. And they had about a month to complete the assignment. They had to self-assess their experience level with the platform. For some of them, they had never used that platform before. We got the vendors to give trial access. So they had to say if they were beginner or intermediate experienced. They noted how much time it took them to complete the question, whether they had to add any parameters. This is a thing that happens a lot in questions that researchers get, is that we don't get all the details of a question. So we have to add some parameters, whether it's a date range or how we're deciding a case is a patent case, are we limited to nature of suit, that sort of thing. They provided their answer, and what became really valuable and really developed our conclusions were the comments they listed. So listing out the steps they took, what they found to be difficult or easy in a platform, pitfalls that they ran into, a lot of the pitfalls that Jim mentioned actually. And then we had the vendors take the test too. So we told the vendors, you know, assign somebody to your test. It doesn't have to be the high muckety muck that might not use the platform every day. It can be your go-to guru, and really see what you can do with these questions and see if you found a way to get to the answer that we didn't. Sometimes our testers found ways to get to the answers with their platforms that actually the vendors didn't, which was quite interesting. Just shows the creativity of librarians, I'd say. Go ahead to the next slide. I'm not going to read these aloud. These are just 4 examples of the questions we used. I'm happy to actually provide the full list of the 16 questions that we created. We found, and the vendors actually told us as well, that they were really great training questions. They are using them internally, the vendors themselves, and other firms have asked me for these questions to train their research staff. So if you're interested in that, I can definitely provide those questions. But I just wanted to show a sampling here real quick. Next slide. So one of the things I just wanted to point out right out of the gate, and it's not a problem that librarians are surprised by at all, and Jim mentioned this as well, is the Paisner problem, as we call it. Paisner data is absolutely terrible. It is a very bad input form, just filled with typos. Lawsuits can actually only have one nature of suit, even though the case can, of course, cover multiple practice areas. Very common in IP law, where it could be both a copyright and a patent case, but the lawyer had to choose just one of them, or they could choose them really badly. There's actually a great article I'm citing to here, a fantastic article that analyzed the accuracy of nature of suit selection. It's quite shocking how bad that makes the data. So that makes it even more important that the platform does some kind of a semantic analysis on the text of the complaint. You need that to be able to carefully assess what the case is actually about, rather than relying solely on the nature of suit. And then name normalization. There's a lot of typos in the law firm name, the lawyers' names, the company names, and Paisner in no way tries to group companies. It doesn't know who's a subsidiary. It may not list all the parties get pulled in. So there's a lot of problems with consistency that requires the platforms, these paid for platforms, to do some kind of normalization or grouping of parties to get an accurate picture. Next slide. So these are just a couple of examples, and they may need more explanation in the breakout room, or if you want to reach out to me further. But here's 2 examples and kind of some conclusions. What became really shocking throughout the testing was the variety of answers that came up. We really had very few questions, maybe 1 or 2, where we got the same answer across more than one platform. It doesn't mean that only one of them was right. It could be that it was right in a point of time, or again, it depends on the parameters that the platform is in some way assigning in the background. This question 1, we actually made question 1 because we assumed it would be the simplest and the easiest, and it actually created the most problems. So here you can see a variety of results from what should be a fairly basic question. This is very low level analytics, what I consider representation analytics. But a lot of problems came up because of, for example, Bloomberg Law doesn't capture pro hoc vice. Irwin and James is a California firm. If they're in Delaware, they're always appearing that way. It could depend on when the docket data was pulled in. So had the defense counsel filed their motion to appear yet? So if they pulled the information into their platform sooner than that, then it wouldn't be captured. And there was an issue in this. One of the platform leaders was actually from this firm, and she knew that an attorney had left the firm and gone to a new firm. So it changed who should be listed. It happened early on in the case. So the question is, does the platform ever go back to the docket data and update it? So that becomes an issue. And the Westlaw Edge one is actually, interestingly, if you know, they're the only one who hit the actual true answer when you look at, you actually pull open the dockets and look at them manually. But it all changed depending on what order you ran the filters on the data. So we kind of list that out there. So you can get to the absolute correct answer in Westlaw Edge, but you had to know what order to start the filtering in. And I'm not going to go into detail, but it basically can depend on the data limits in terms of how much data it can pull in. And so which limit you choose first can affect what's going on in the background. So that's a real quick version of what happened there. Next slide. Another one here is a case law research question. So in a lot of ways, analytics can enhance your case law research by getting some numbers behind it, but you have to be careful about going to that first rather than also using it in tandem with case law research. So again, this is a fairly straightforward question, but it becomes complicated when you think of the issue of tagging the case as a patent case. So again, there were false hits because the case wasn't a patent case. It might mention patents. So there was a famous copyright case in here that some of the databases tagged as a patent case just because it had to do with patent literature, non-patent literature, but it wasn't actually anything to do with patent law. And again, it depends on if they're searching motion rulings versus case opinions and that sort of thing. So it's a wide variety of answers from a fairly straightforward question. Next slide. I'm not going to read all of these, but I want to kind of focus on a couple. Probably the second one listed there is probably the most key. Analytics research cannot exist in a vacuum. Depending on what results you're trying to get to, you probably need to combine it with case law research. You probably want to look at the dockets, like actually open them up and see if they're accurately pulling. And the company structure, and this is where it comes in real key, that you have somebody helping you with this research that understands corporate research. So of course, I'm thinking of librarians like myself. If you aren't searching the right company, you've got a big problem. And most of these platforms, they can do some kind of, they've got some kind of corporate database behind the scenes, pulling in subsidiaries, but perhaps you don't want to pull in all the subsidiaries. If it's a large company where it's key where what section of the company is actually relevant for the research you're doing. If it's not capturing changes in names, so all of a sudden you're only capturing a slice of the case history. So doing the analytics in tandem with other research tools is so incredibly important, and having the right people who can do that kind of research. The third item is probably my biggest soapbox to get onto, which is the transparency needs of these platforms. I'm not saying we're asking any of the platforms to give us their secret sauce, their algorithms, that sort of thing, but we need to know exactly what it can do and what it can't do. And there's nothing wrong with the platform not being able to do everything, and there's nothing wrong with the platform having some potential for errors. We just need to know what those are so that we can work around it and provide the right caveats. So if anyone was going to ask me what the #1 thing is, I would always say it's transparency, and everything else falls from there. And then this is just a quick snapshot of the comparison we built. It actually started with me on my own back in 2016 when I was just trying to figure out what product to buy. 2018, I actually partnered with Northwestern's very own Jesse Bowman, who teaches law technology, I believe, at your school. And he helped me expand this in December 2018. And then there's the July 2019 version, which is pretty much impossible to print out. We analyzed 75 different factors. We included links to coverage and user guides. I've just received updates from most of the vendors, and we're trying to update that in the next couple of months to reissue it. And the comparison is available to AALL members. There's probably a member at your firm if you're at a larger firm, definitely a member if you're an academic. If you are interested in getting it, it's pretty, just doing a little plug for my organization. Anyone can join our association, even though it sounds like it's just for librarians. And there's a lot of great resources through that organization, including this platform comparison. So I think I zoomed along here. I think that's my last slide.
Thank you, Diana. Well, those were 3 great presentations, and we have some excellent questions in the Google Doc. So thank you to our audience for contributing these questions. So we've got an opportunity, people can post questions, you can add +1, and a couple of questions that have risen to the top are about ethics. So I think let me ask these questions, and I just want to ask each panelist to respond, Megan, Jim, and then Diana. So there are questions about kind of worries about have and have nots, and maybe further division in the world already. We already know that legal services are expensive, and there are concerns about the expense of legal services. So will data analytics further divide the world into have and have nots? And then I think a related question that is just the ethics of how these predictions are going to be used. My colleague in computer science, Chris Hammond, is very interested in that question. I know his other colleagues too, like how might this be used in abusive ways? And Simon pointed out, so Justin had the question about ethics at large. Simon pointed out France has banned the use of analytics in their courts, which was got a lot of attention this last summer, and was a bit controversial. But so Megan, I don't know, you can pick anything there that you'd like to chat about, but the ethical side of this, what should we be thinking about?
You know, I think at least the data analytics that I've sort of live in, I think is something that really can be accessible to almost anyone. I mean, quite frankly, you could do a lot of this with, if you're a sophisticated Excel user. And there's also a lot of good free resources. I mean, one of the things that I was going down a path to look into to add to our database was, you know, trying to sort of mine the data of certain decisions by certain arbitrators or judges. And I thought I had this great idea, and I brought it to my, you know, my working attorneys, and they said, well, why would we ever do that? Because the AAA has this really great tool where you can sort by, you know, for this body of cases by the arbitrator and their decision and the issues. Why would you ever try and recreate that? So I do think, you know, some of these the different AI tools, there may be different considerations, but at least for the core data analytics, you know, it doesn't have to be the big sophisticated law technology group. There's a lot of ways you can implement it, I think, in your practice.
Yeah, great point. So we should be developing tools to make it easier for people to make the most of these. And so the flip side of that is perhaps this will be a revolution that'll make the justice system and legal services more accessible to everyone, hopefully, and rather than going the other way.
Right.
Jim, what do you think about these questions?
Yeah, so there are 3 points I want to address. The ethics question, the societal question, and the French question. I'll bridge it that way. On the ethical question, I think that the reality is, as a litigator, it has been modified over time under the model rules, but we have a duty to be zealous advocates for our clients. We also have a duty, an ethical duty under the model rules, to be conversant with technology and the benefits of technology for our clients. So, for example, ethically speaking, in the future, if it would cost a lot more for a human being to do something than a piece of software, and that the software would do a better job, we have an ethical duty to tell our client that and probably use the software. But also from the standpoint, I'm a litigator, and my job is, within the rules of the court and the ethical rules, is to win for my client. And any possible tool that I can gain access to that would help me understand the judge better and present my case in a more persuasive manner, that's what I absolutely would do. That's completely consistent with the way the model rules are set up ethically, but I do agree that there is a digital divide. There definitely is an advantage to people who can use those tools and who can't. I actually agree with Megan that many of these tools are free, but you still have to be trained to use them, and you still have to know how to use them correctly, and so there's a training gap. Even if the tool itself is free, how to use it is there. But I actually think there's a bigger problem that I worry about. With all of this technology, COVID, the current environment we're in, it has an advantage to established lawyers. So if an in-house counsel has a patent case somewhere, they might do a filter, just like you would go on Amazon. I only want to consider someone who's been to trial 5 times and has appeared in front of this judge 10. You can run that kind of search, putting aside the problems with the search results, the Paisner we talked about, but you can run a filter. And that filter would create a chasm that would make it very difficult for young lawyers to break into it. In the patent litigation space, if you ask who were the top 10 patent litigation trial lawyers in 2000, and then you ask in 2010, it's the same group, they're just 10 years older. And if you ask in 2019, with the exception of 2 retirements, you know, you could argue that the same 8 people have been for the last 20 years the quote-unquote go-to trial people. I'm a Generation Xer. I keep waiting for the baby boomers to go away, and they don't. Every day it's the 70 is the new 50, or 80 is the new 60, and I keep waiting to bust into that next group. But it is a major problem for the young lawyers. How do you get the reps? How do you get the experience? When you're a client and you have to spend your limited dollars, you want to have someone who won before the judge. That creates a chasm, especially when you have systemic racism and other problems that we've had in this country where other groups have not participated. And I think that's a very good reason why we need affirmative steps and have companies push getting younger lawyers opportunities. And younger lawyers' opportunities will automatically, because the legal profession is much more diverse at the younger ranks than it is at the older ranks, it'll help address some of the issues. But the problem is these tools, any individual client says, I don't want to be the first trial for anybody, that creates a real problem for younger lawyers and groups to break in. So I think that as a societal issue, I worry about that. The French one is ridiculous. Let me be really clear. The French one was that they don't want to be embarrassed. They like the illusion that all their judges are fair. And it's actually illegal to point out that one of their judges may rule badly against some group in society all the time. You can go to jail by pointing out that a judge is discriminatory. That is ridiculous. The reality is that all it has done is that people outside of France who don't touch France sell data analytics about French judges, but they make sure that the data stays outside of France. I mean, it's a ridiculous decision. But the reality is the genie's out of the bottle. We have to make the tools accessible, and we have to make the training accessible so people know how to use it. You have to have a certain level of training, and I am worried that one of the big chasms is the training and knowing how to use it.
Thanks, Jim. So we have at least one French lawyer who was in the chat, so maybe you didn't describe the decision real well too. We should point out, of course, France has a civil law system, and that was part of the justification given for this. And of course, we have our own problems, as we've discussed here in the U.S. too, where we may be able to engage in analytics, but we can't actually get to the data. So can we really say we're any better off, right? But so just sticking up for the French just a little bit there. But Diana?
Yeah, and we followed that issue closely. It actually happened while we were starting the testing, so emails were flying around. I'm happy to post a couple of articles about that, including an article by the guy who built the platform. He did it as a free system, and then got in all this trouble. So I will add that to send. It's quite fascinating to read, especially when you hear directly from him what happened. So I do think there's a legal technology gap. I'll just say that out of the gate. I think it's going to create a significant problem over time. Anybody who buys these platforms, so somebody like me who has to purchase these every year and budget for them, the prices for these platforms go up significantly every year, and it's far beyond the rate of inflation. And every year I have to argue with them, like, where does this cost come from, this increase, when your platform maybe has not developed significantly to justify it. So that just continues to create the gap. The other gap being created, to be clear, is these platforms have always focused on large commercial law. They don't cover a lot of the matters that are key to access to justice issues. They generally don't cover criminal cases. Docket alarm is the one exception because they don't limit the case types. And they don't cover a lot of small cases. So they don't cover like eviction cases generally, those kinds of things. So the kinds of cases that actually matter to the majority of Americans, not to corporate America, where analytics could really show where the justice gap is, these platforms aren't covering that. You'd have to do it through manual projects, which there are groups out there that are trying it. I've been trying to talk to the vendors about building for these groups as really, I mean, I consider it their obligation to do their kind of pro bono work in our community, is to develop these platforms for groups other than the big clients who we are paying them an arm and a leg year after year for these platforms at ridiculous rates. And actually, I've had some success. Docket Alarm is actually partnering soon. We're in the works of building it with the Lawyers Committee for Better Housing here in Chicago to help them get the data they need to do the analysis. The analysis they've built in-house and to enhance it has shown significant differences in the eviction rates depending on the area of the city you live in, which of course largely correlates to the race of the tenant. So that's my big issue, is that these platforms really aren't assessing the entire legal ecosystem, and they really do focus on big money cases, no surprise, to sell it better. And on the one other ethics side I'd say is, and I think you'd see it more once you expand the database of cases to these smaller cases, is the data can be misinterpreted. So we're starting to look at housing casing data and housing case data, and what we saw is it'd be very easy to misinterpret a judge ruling more in favor of the landlord versus the tenant and making bad assumptions on that. So it's very dangerous at times at how you're looking at the data and making judgment calls. Again, Jim pointed out, depending on how big of the data set it is, and not knowing kind of what tagging or things are happening in the background that could change your perception of how a judge is ruling. So there are definite ethical issues surrounding this data. I don't say that in any way to discourage people from using it. I'm a huge fan of data analytics, but there's a lot of caution you have to go into it with.
Thanks, Diana. Well, we have a few questions here about the team that you're putting together inside of your organizations. Megan, I think, why don't you address this question and just talk a little bit about, well, Diana's talking about the way librarians are contributing in this area. Many firms and legal departments have been hiring data scientists. Why don't you tell us a little bit about the team you have at Bryan Cave helping you do this work?
Yeah, absolutely. So, I think the team concept is really important too. We do have, a whole separate, it's even branded separately, BCLP Cubed, where they really have the technology expertise. But I would just say the most important piece is to have many different perspectives when you're looking at any one problem. So, if I just handed some issue off to the technology team without being intimately involved in how you're going to develop that, you're not going to get the best solution. So, even though we have a large group of software engineers, data analysts, and people who sort of live and breathe this stuff every day, I don't need to. I'm a partner. I've got my limited area that I'm focused on. It's just about knowing your resources that you can go and get that. And so what I'll do though, if I've got a client issue that may be able to be resolved with technology, I will put the technology people, myself, the working attorneys, and the client on the phone together, and so that everybody's hearing the same information and collaborating. And it's really through that diversity of perspective that you get the best solution.
Thanks, Megan. Jim, we have a question here about the modeling process and advising clients. I think people have seen now more and more some of the descriptive statistics that are available, but how do you actually put that into practice? How do you develop a model, and then how do you actually present this advice to the client in a way that it's actionable, they can do something with it?
Well, I'll give you an example. In some ways, it's just like real estate. So let's say a company wants to make an equity investment in a company, or a company is going public, and the investors want to know how likely it is that company is to be sued, how often, where, what the risks are. You can then you get around with the client, you find 4 or 5 comparable companies, you then look at their litigation history, you then look at where those companies were sued, you then look at the direct competitors and see how the direct competitors have their litigation history, because they're the only ones who could get lost profits, they're the only ones who could get an injunction. Then you put together a model that kind of does a best case, middle case, worst case scenario on likelihoods. And then, you can then start doing some pricing models. I think that one of the big things for investments or anything is someone's trying to put some natural bounds on things. And that's where you can work with the data sets available. There's a wide range. There's a whole bunch of companies that sell data, as well as for the larger firms, Diana had mentioned the data sets. The bigger firms are now trying to use their own internal data sets as value. We're the only ones who have access to the Wilson-Sonsini data, right? And then we're trying to show the value of that happening in areas where we practice, right? So I think that happens a lot. And so I think from the standpoint of letting know kind of the different scenarios, it's no different than if you buy a house on the coast. How often is a hurricane going to happen? It's very much like real estate or an insurance, trying to get some logical stuff. The one thing you have to understand is you can never plan for a black swan event, right? Just because something has never happened doesn't mean that it won't. And you need to have that discussion. And that also depends a lot on trust with your client and making sure you understand their risk tolerance, right? Just because 4 out of 5 dentists recommend Trident doesn't mean that you should actually chew gum, right? And so having those discussions, I think, are good. And I think, but the tools really help you put an analytical framework that didn't exist before.
Thanks, Jim. So Diana, in addition to these different platforms, what kind of tools are firms using for, once you get that data, for representing it, for doing this modeling, for working with that? Megan alluded to like using Excel, for example. You can do a lot there, and we sometimes forget about how much you can do in a basic tool like that. But what other tools are we seeing firms use in this space?
Well, outside those 7 platforms, there are also some state court platforms that are coming into the market, and often they originated as advanced docket platforms, and they're starting to do analytics on that. The Excel point Megan pointed out, so key. One of the things we looked at was to make sure the data could be exported from any of these platforms, so that you could then manipulate it, or maybe perhaps overlay some of your own data or other parameters on it. And in the early days of these platforms, that often wasn't available. All of them generally have that available now. So that's very key. So having strong Excel skills can be incredibly powerful for enhancing the data coming out of these platforms. And some of them are more adaptable. So I mentioned docket alarm. When we were creating this, we were trying to create from an apples to oranges, more of an apples to apples comparison. And I joked that docket alarms like the kiwi in the mix, which they've kind of embraced that idea, because they're highly adaptable. They actually will pull in all docket data from any court they can pull from. And then everything's very Boolean based, and the exporting ability is very strong. And then they also have a sandbox tool where you could use your own internal data. And so if you didn't have data scientists, for example, perhaps at your firm, they've built some tools that would maybe people with a lower level of technology ability can partner with the product they have to enhance your own internal data set. So there's a lot more platforms coming on the market and legal tech companies that can help fill that gap. So again, if you don't have a data scientist at your firm, though we're seeing that role increase, you could buy a product that could help you manipulate your own internal data to get some good results. But again, it's often just this combination of docket data, analytics data, case law data, internal data. So a lot of the experience management systems that you see out there, things like Foundation, I think you're going to see partner more with these kinds of platforms, or being able to, again, pull data from there, pull data from the analytics, the dockets, and marry it all up to an internal system. So I think you're going to see more collaboration among these platforms, which again makes it so key that you can export well the data.
Thanks, Diana. Well, so I want to give each of the panelists a minute for some final comments before we go into the networking period, where we're going to do the breakout rooms and get to know each other a bit. But so and I'm wondering if in your final comments you might address, there were some questions here about liability and malpractice, and I know that we're thinking constantly too about how we make sure we use data responsibly and not in a way that a client would think that we misinform them. And of course, there are professional obligations, Rule 1.1, about using technology, understanding benefits and risks. There's lawyers are limited to charging only reasonable fees. There are questions about if you don't use some of these tools, maybe now that you're not taking advantage of things, that could lead to charging appropriate fees. You got to think about confidentiality. So they're supervising. If you have data scientists you're working with, for example, making sure you properly supervise and understand actually what they're being done. So how do we, now the thing I worry about sometimes about bringing up those questions is, as lawyers, maybe we use those to kind of keep the competition out and not change the way we're doing things when we want to be driving change forward and using the benefits of innovation and technology. But Megan, I guess just in your closing thought, I'll give each of you a chance for closing thoughts, but what do you, I mean, you've all bought into this, you're using it in your practice. Where are the opportunities and how do we keep making sure that we're doing this well and doing it as a positive for our firms, our organizations, and our clients?
I mean, in my practice and how I use it, I think, the key is if you're going to be making decisions based around data, or you're at least going to be using it as a tool to figure out where you're going to go, you better make sure that the data you're basing these decisions on is accurate. I mean, I guess getting to your malpractice question, originally back in the earlier days of this program, we had this database. That doesn't mean that all of our working attorneys are inputting all the information that they should be. So, even with us in a closed loop system, we had to input different processes and procedures to sort of be on the management level, checking and making sure that the working attorneys are really getting the information in the database so that we can actually make informed decisions from that. And my sort of tip on that for anybody who's looking at utilizing this and working with other attorneys, you really have to onboard people. You have to show them how this is going to help them in their practice. Now, it may benefit me from the matter supervisor level so that I know what's going on and I can communicate with the clients, but I've got to convince my working attorneys why it benefits them as well, and sort of onboarding them in that process and making it easy as you can so that it's not taking up a bunch of their time and that they don't resist sort of this data collection.
Great, thanks, Megan. Jim?
Yeah. So I have just 2 points. One is on the side, because I very much enjoy the practice of law and being in court and litigation. And it is important to recognize with all this technology, there's actually a premium and advantage to the traditional skills. Being good in terms of oral presentation, being an excellent writer, is in fact a premium, because most of the time in a data-driven world, people don't see the advantage of it. And so it's very important to understand the value proposition of what you're offering and when you can present it. And people sometimes miss the boat on that. I mean, we've all read Susskind, and he has a lot of good points, but he completely misses the boat that when you're in the courtroom, you're at trial, or you're in a negotiation, how you present and how you carry yourself and how you can work with the room and the other people is enormous. And that is still center of the profession. The second point I would make, and I think I saw it in the chat, is the world's changing. I mean, my firm, Wilson Sonsini, we have a chief data scientist who I talk to regularly, right? We have a number of other people in the technology. I'm on the technology committee, even though I'm a litigator. And then also the firm has a software company. We actually have a subsidiary that designs and develops software. So the world is changing, but the funny thing about the change is that there is a premium. And if you think about it, it's not different than the rest of the society. I don't mean this as a good point or a bad point. If you ask what restaurants are doing well, they tend to be all these very small shops with customized cooks and fusion cuisine or Michelin stars or whatever. And you know, the ones that are not doing as well is a place that I used to eat a lot at, like an Applebee's. But you know, basically the reality is in the profession, if you do excellent work, there's still an opportunity there. The main concern I have is the one I've been saying to many people already, is the chasm of how do you get junior lawyers the experience that they need to cross that so that they can succeed and really enjoy the profession. It's still an art. You just have to understand the data is a major gating item, and it's part of the art now.
Thanks, Jim. Diana?
Yeah, so I won't speak to malpractice issues as a non-attorney, but again, it just goes back to making sure what the other ones have said about the data set being accurate, making sure the right people are helping you along, and call the vendors. I mean, most of the vendors will walk you through a problem, help you create the search. So if you're any level concerned, so if you're using, again, an out-of-the-box solution rather than an internal one, don't hesitate to reach out to these vendors to make sure you're using it accurately. We do it fairly frequently, and my team is very experienced in using these databases because we want to be absolutely sure. I know there's a comment about cost. Our firm actually doesn't charge for any database use to our clients. We consider that all overhead, and I think you see more and more firms moving to that, so it's not an issue of passing the cost on to the client, but it does become more of an issue then of what we can afford to buy, since we can't pass the cost off to the client, and being very careful about what we invest in. And then what I'd say to especially the students on the line, embrace technology. I can't stress enough the importance of taking the law technology classes that you have, going to demos, offering to be trial participants as these platforms develop. A lot of firms have some sort of technology committee, if that's something that you can get on early on. I know at my firm, the attorneys who are good at technology and are open to technology, aren't afraid of it and are willing to learn and be on trials, they are really seen as incredibly valuable to the firm beyond just their billable practice. And I see them in high demand, not just in the technology areas, but it really shows an attitude of openness and willingness to learn. So I just can't stress enough how important that is. And so to the vendors on the line, if there are any, get in these schools, get them access. I often help a lot of my academic colleagues. I talk to my vendor contacts to get them access for their classes. They shouldn't have to beg for this access. If you want to sell these products to the firms, convince them early on while they're in school and get them the trial access. I know Docket Navigator gives free, I believe, and I hope I'm not quoting this wrong, but I believe they give free access to law students. You just have to reach out to them. And if I'm wrong, Docket Navigator people who might hear me say this, I'm sorry, but I'm pretty sure that's right. So more of the vendors need to do that. They need to recognize the need to get to the students early, because I completely agree, of course, with Jim on that, of filling that training gap, which means starting people early on these products.
Thanks, Diana. And I should mention that there's a team of researchers here at Northwestern who are working on a project. It's been branded as Scales now. And as a matter of fact, they've expanded that. It includes some folks from other schools. I mentioned Chris Hammond, who does a lot with the Law and Technology Initiative, helps me put together these events. He's a big part of that, as is Dave Schwartz in the law school and many other researchers here at Northwestern. But they're getting data from Paisner and building an interface, building tools to work with this data, to better understand the data, to make it accessible to, I mean, right now, really, if you want to get in there and do something with the data other than on some of these platforms, I mean, you would need SQL skills or some other tools, right? And you need to understand the legal jargon, but how can we build systems? This is something that Chris Hammond has spent a big part of his career building systems that would make it able for anyone to kind of have the data science skills to understand that. And I think that could be a huge contribution to better understanding the judiciary to have these tools. But of course, we need the data first, and maybe things will change. Maybe Congress will pass a bill at some point and make all the Paisner data available to everyone. We'll have to see. Meanwhile, there are many organizations doing more and more work to get that data out, to make it available, and other projects underway like that. But we're getting ready to go to the networking portion of our event. But before we do that, I just want to give virtual applause and real applause to our panelists. Thank you so much, Megan, Jim, and Diana, for joining us. This has been a little bit of an experiment, right? We're moving these events online, and we would have been in person when we did these events last year.